Joining us to talk a little bit more about this is political analyst Professor Dirk Kotze from UNISA. Professor Kotze, very good evening to you. Thank you so much for speaking to us. I don't think this is the first time we've spoken about the matter. There was much speculation about whether or not this extension ought to be granted, but I think a lot of those who were on the side of progress were saying that the Constitutional Court should grant this if we're ever to get anywhere with this particular matter. Your thoughts?
Yes, that is indeed so. The National Assembly has already voted on it and approved it. So it is essentially in the hands now of the National Council of Provinces. But because there are some amendment or some changes that is now at the NCOP, which were not approved by the National Assembly, it means that there's now additional processes of public hearings that are supposed to take place also. There's also an element in it which is now included to say that after the election of 2024, next year, that a more comprehensive review of the electoral system will have to be taken or will have to be done so that it is much more than what this current amendment includes. So there are some elements now which there's more or less agreement on, but it has to go through the procedures, the constitutional procedures of adopting an amendment act. So in that sense, I think this is what causes the delay. It's not so much about principled issues in Parliament where there's differences of opinion.
But just for those who haven't been following the story very clearly, basically, in broad strokes, what is at stake here? So we're talking about giving independents an opportunity to contest the elections at national and provincial level. But more importantly, there is a public hearings that will include, amongst other things, the threshold for signatures for independents. Why are all of these issues important for the ordinary man on the street, so to speak?
Well, it is about, first of all, to what extent there is some parity between or equal treatment between the 50% those that are on the PR lists versus those that are standing on their own, whether they are nominated by parties or completely independent candidates, and where the requirements are a certain number of signatures. That they argue, especially the civil society organizations, are too high, that it will make it exceptionally difficult for these independent candidates to qualify as candidates in the first instance. Also, the fact that there is, when it comes to after the election and when the seats must be allocated, and remember there's going to be, in terms of this new amendment, there's going to be 50% of all the members of Parliament who could be independent representatives, that there will not be an equality in the allocation of these seats, that some of the independent candidates will actually require more votes in favor of them than others, and that it will be also much more than what the PR candidate representatives will require to be elected to Parliament. So it's a question about equality in terms of the number of votes that's required for independent candidate versus other candidates to become a member of Parliament.
There have been those who've accused Parliament of dragging its feet on something that really should have been concluded a while ago. But as you mentioned or intimated earlier on, the Minister of Home Affairs is saying that ultimately the goal is to ensure broader reforms in terms of electoral laws or reforms.
Yes, that is indeed so, but that is not what the Constitutional Court judgment actually demanded or that they expected Parliament should do. The Constitutional Court judgment was purely about the independent candidates. So out of this process developed, therefore, demands or expectations, especially from civil society organizations, that it should go beyond what the Constitutional Court judgment was, and that it should be, in effect, a complete overhaul of the electoral system instead of purely looking or focusing on the independent candidates and bringing them into the national and the provincial elections, as they are already at local government level. So it was expectations that were created that really brought us to the point where we are now. But I think one has to say and give credit also to a lot of work that has been done by civil society organizations, think tanks and others in these 2 years. I think the problem is that Parliament became involved at a too late stage, and that is why these delays are now happening.
Should there be concerns about whether or not this matter will be concluded by 2024 and in good enough time for independent candidates to be able to take part in the next general elections?
Well, I think the issue is to what extent will the IEC, the Electoral Commission, be able to implement the amendments. And I think what I've mentioned earlier on is very important, and that is that to a large extent the principles of the incorporation of the independent candidates have been concluded. And that is that it will be on the basis of 9 constituencies which are identical to that of the provinces, and which will make it relatively easier for the IEC in order to determine how these constituencies will be or demarcated for the 200 independent candidates. If it was a different system with a different number of constituencies, or if they decide now to have more constituencies, then it will become a completely different ballgame, which will compromise the situation. So I think what I understand is that the IEC uses this as the point of departure already, and they are already busy with preparations, and therefore there is not, by implication, a delay in the preparations that the IEC should make.
Political analyst at UNISA. Thank you so much for your time, Professor Dirk Kotze. Right, we're going to leave it there.